limited readjustment clauses to 3 years because of questions regarding recovery of costs associated with Section 111D compliance. Is that correct?
That's the way I interpret what I just read, yes.
Mr. Burton, could you, I'm sorry, scroll down and show us footnote 18 and footnote 19? I assume footnote 18 is a reference, is the citation to the Section 111D.
Your Honor, I don't plan to enter this exhibit, but I do have extra copies if you would like me to.
Well, if you just show me on the screen, then just, in the context is, okay, so 18. Okay, thank you.
Mr. Rogers, do you know how long the proposed rider US-1 would be in effect if approved?
The rider is for the life of the project, or yes, for the life of the project, or a 25-year period, I believe. I can't remember the exact length, but it's for the life of the project.
I was going to ask if, to your knowledge, this project have a 35-year operational life.
Yes, it does.
So in any event, 25 or 35 years, this rack would be in place for much longer than 3 years. Is that correct?
Yes, it is.
In other words, approval of rider US-1 would mean that for the next 25 to 35 years, customers could be responsible for a rate rider that is, in your words, an essential component of clean power plant compliance. Is that correct?
That's correct.
Mr. Rogers, are you aware of recent legislation supported by the company with the stated purpose of providing Dominion's customers with rate stability as Virginia plans for clean power plant compliance?
Yes.
And are you aware that that was embodied in Senate Bill 1349?
Yes, I am.
And is it correct that Senate Bill 1349 has approved locks in the company's current base rates for the next 5 years?
Yes, it is.
In light of the company's request for a subsection A6 rack recovery for the Remington solar facility, I would like to ask you about certain representations made by the company as to what Senate Bill 1349 would mean for customers. Now, at this time, I'd like to have a document distributed and marked.
Give everyone a chance to look at that, at this. Any objection? Mr. Burton has handed out an opinion letter from the Daily Progress posted Friday, February 13, 2015, entitled Bill A Plus for Dominion Customers. I will mark this opinion letter as Exhibit 6 and admitted into the record subject to cross-examination. Is there any-
I haven't yet moved to do so, but
Oh, okay,
I
never
certainly,
mind
I'll move to do so now.
Were you planning on it?
Yes, Mr.
Okay,
Honor.
all right. Then, so we'll admit it's subject to cross,
Thank you.
or further examination.
Thank you. Mr. Rogers, what I put on the screen here, I hope you have a copy and had a chance to review. Does this appear to be an opinion letter posted on February 13th of 2015, authored by Mr. Dan Weekly, who is Vice President of Corporate Affairs for Dominion?
Yes, that's what it is.
Okay. And here, in the highlighted text, Mr. Weekly represents that Dominion would assume the risk for clean power plant compliance costs for 5 years. Is that correct?
Yes.
And we have established here this morning, I believe, that the Remington solar facility is an essential component of the company's strategy to assist Virginia in its compliance with the Clean Power Plan. Do you agree with that?
Yes.
So my question, Mr. Rogers, is how is the company's prior representation that under Senate Bill 1349 that the company would be assuming the risk for Clean Power Plan compliance costs for the next 5 years consistent with the company's request to establish a subsection A6 rack for the Remington solar facility?
My understanding of the way the legislation has been put together and the way the legislation was finalized is that the transition period base rate impacts would be related to impairments, write-offs, plants that are abandoned or whatever as a result of the clean power plans. My understanding also is that the bill still provides for A6 recovery for projects that are growth projects to meet customer demands and customer needs. And as I said a few minutes ago, clean power plant compliance is part of this, but we also have customer needs for this plant. It's been demonstrated in the RFP. It's a positive net present value for our customers. As far as the gyrating further on the details of the legislation, I would pass that to council, but that's my understanding of the difference between the two.
And I appreciate that, but irrespective of the legislation and the inner workings and the weeds of that, just focusing on the words that are on the page before us here, do you believe that, I'll ask the question again, is this statement consistent with the company's request for a subsection A6 rack for the solar Remington facility costs?
In my opinion, it is consistent because there's a difference between stranded assets and impairment and growth to meet customer need and growth to have a diverse portfolio going forward.
Does the word stranded assets appear in the language?
No, it does not.
What it does say is that the federal standard being the proposed EPA Clean Power Plan could cost at least $5.5 billion to implement, and that under the bill, Dominion would assume the cost for those for the next 5 years. That is what it says.
That is what it says, yes.
Mr. Rogers, isn't it correct that the risk for assuming Clean Power Plan compliance costs falls on the customers when the company seeks recovery of such costs through a rate adjustment clause?
Could you say that sentence one more time? I'm sorry.
I'll reference back to our conversation earlier about the difference between rate adjustment clause recovery and base rate recovery.
Okay.
And we discussed that rate adjustment clause recovery means increase in rates irrespective of what's going on in base rates. Is that correct?
Rate adjustment clause would be outside of base rates, yes.
In addition to. So with that in mind, isn't it correct that the risk for assuming Clean Power Plan compliance costs falls on the customer when the company seeks the recovery of such costs through a rate adjustment clause?
Any cost that we would ask for recovery through a rate adjustment clause would impact a customer, yes.
Inversely, isn't it correct that the risk for assuming compliance with the Clean Power Plan would be assumed by the company if such costs were recovered through base rates and at least during the period of the base rate freeze?
During the transition period, yes.
So Mr. Weekly's comments here before us, they'd be more accurate if the company were to recover the Remington solar facility costs through base rates and not a subsection A6 rack. Is that correct?
That is not my interpretation of Mr. Weekly's comments. I think you and I are going to agree to disagree on this particular topic.
What do you disagree with me about?
I believe that the legislation allows for recovery of our growth projects, of which the Remington solar project is one of those, through an A6 rider.
And again, irrespective of what the law is, I'm just speaking to what's on paper here before us and asking you if these comments would be more consistent if the company were seeking recovery of the Remington solar facility costs through a subsection A6 RAC.
I'm looking at a paragraph on an opinion piece here, and I'm comparing that to actual legislation that exists and what the legislator has stated in that legislation, and just don't necessarily agree with your conclusion.
Mr. Rogers, if using today as a baseline, if the company were to seek recovery of these costs through base rates as opposed to a RAC, would customers' rates maintain more stability?
Are you asking, please ask that question again. Thank you.
Using today as a baseline, say the company sought to recover these costs through base rates. Under that scenario, would customers see more rate stability as compared to recovery through a subsection A6 RAC?
If this particular project was recovered through base rates through an A6 rider, the specific increase in customer bills related to this project would not occur.
And would you equate no increase to more rate stability?
I don't like to draw a conclusion on the term rate stability because there is a wide range of things that go into customer rates.
$0 is closer to, an increase of 0 cents is closer to rates are today than an increase of 5 or 6 cents.
If this particular project was in base rates, there would be a lower impact on customer bills.
In fact, there would be no impact on customer bills, is that correct?
That's correct.
All right, Your Honor, thank you very much, Mr. Rogers. I appreciate your time today.
Thank you. It was a pleasure.
Just to confirm, Your Honor, that the exhibit was moved into the record.
Yes. Mr. Lucy, Ms.